Hi, this is Sarah Butters. I am the Division Director for the Probate and Trust section of the Real Property, Probate and Trust Law section of the Florida Bar. We have got inundated with remote notarization, questions, effective date questions. What can we do to loosen the strict witnessing requirements for execution of wills in this time when it's difficult to meet with clients, let alone gather witnesses and the necessary people to execute an effective estate plan in Florida. So I just wanted to do a quick podcast. I'm not experienced with any of this. We're also broadcasting live from my home in Tallahassee where I have 4 dogs. So be patient with me. I'll try to get through this, but I want to answer a bunch of questions because I really can't get to all the emails that I'm getting right now. So first, I want to talk about the Florida Supreme Court's order regarding remote notarization, or I should say remote oaths, notary oaths to allow people to testify and give testimony in court hearings or proceedings, and how that might apply to the execution of wills and trusts. And then also talk to you about the remote notarization legislation that passed last year, its application to electronic wills. And then the last thing I want to talk about is what are there other options regarding judicial or governmental intervention in to loosen the evidentiary standards, or execution standards for witnessing or notarization of wills. So let me first talk about the Florida Supreme Court's order. So on, what was the date? March 18th, 2020, the Florida Supreme Court entered order dispensing with the necessity of notaries conducting, testimonial oaths, giving testimonial oaths in person if there's a video feed or if the notary actually knows the person who is being sworn in. And so that remote notarization authorization by the Florida Supreme Court dispensed with the necessity of meeting in person. But by my interpretation, and I'm just one person, that order is limited to testimony oath for purposes of hearings and trial proceedings and court proceedings, maybe depositions, things like that, clearly depositions. But it doesn't necessarily apply to transactional documents like the notary giving oaths on a self-proof affidavit, and clearly, or more explicitly, the only documents it appears to apply to are family law forms. And so I think the fairest interpretation, or at least the most safe interpretation of that Florida Supreme Court order, is that it doesn't actually authorize remote notarization of wills and trust documents at this time. I will remind you that we do have the ability to do remote notarization of transactional type documents as of January 1, 2020. So loan transactions, deeds, real estate transactions, we've been able to do that since January 1, and there are some providers out there that can assist you with that. There are a significant amount of remote notaries who took the educational course and are now capable of doing this. And so to the extent that that's useful to you all, I encourage you to look online and find those providers. But I don't believe it is useful for estate planning documents, because that same legislation that permitted remote notarization of of transactional type of documents also authorized remote notarization of estate planning documents, but the effective date for estate planning documents is delayed until July 1, 2020. Again, estate planning documents include wills, trust, anything with a testamentary effect, as well as durable powers of attorney that are not transactional in nature, that have some of those superpowers like estate planning powers, gifting powers. Those, as well as healthcare surrogates and living wills, have to be done or can't be done remotely until July 1 effective date. So I don't think the Florida Supreme Court order helps us much in terms of being able to do remote notarization of wills and estate planning documents. But even if remote notarization, even if that, or if I'm wrong and that order does apply to all kinds of documents, not just family law documents, the real problem is that estate planning documents require witnessing. They actually don't require, for the most part, other than durable powers of attorney, notarization. And so that Florida Supreme Court order doesn't apply to the witnessing of estate planning documents. Again, you need two witnesses and the testator to sign in the presence of each other in order for those documents to be valid. You don't need a notary. The notary is extra for self-proof evidentiary reasons, but they're not necessary. So even if you could remotely notarize those documents, you still have the problem of being able to do remote witnessing of those documents right now, which you can't do until July 1, 2020. We also, I would remind those of you who get excited and say, well, at least we got a solution July 1. The problem is that there is a carve out for vulnerable adults. So if the testator falls within that category of a vulnerable adult, they cannot use this product even come July 1. And a vulnerable adult, there's a definition in the statute, Chapter 415, if you want to take a look at it. Essentially, it's persons who, because of an infirmity of aging or some sort of vulnerability, need assistance with daily care. So those persons are going to be carved out. The nice thing about needing assistance with daily care is you've got one witness at least that can help you do the execution of those documents, and hopefully you can round up a second one. But if you need assistance with daily care, you typically have a visitor daily or at least a couple times a week that could assist with remote or witnessing of these types of documents. So in summary, I don't think that the Florida Supreme Court's order dispensing of in-person notarization really helps us much in terms of getting estate planning documents executed right now. So a follow-up then to sort of that conclusion is, well, what options do we have? And we've gotten a lot of questions about what options are out there either by the judiciary or the executive branch to loosen the will execution requirements. Can the judiciary, through its equitable powers or procedural rules, dispense with the necessity of witnesses? Can the governor, through his regulatory powers, dispense with the necessity of witnesses? And some of the doctrines that have been thrown out there is sort of, what about the harmless error rule? What about the substantial compliance test? Are any of those things available to us either through executive order, judicial decree, to help us start to be able to execute these documents in a more less strict manner than the statute currently requires? And the short answer is not at this time. I believe, after sort of doing a lot of analysis of this, that the only fix that can come to those statutory witnessing requirements needs to come from the legislature, because it is a statutory requirement. I don't believe that the governor can intervene to eliminate the witnessing requirements on wills, because it doesn't fall within the purview of sort of the executive branch's regulatory matters. Certainly notarization falls within the governor's regulatory matters, but that doesn't help with witnessing requirements. I also don't believe that it falls within the judiciary's powers to be able to dispense with a clear statutory requirement. And so while the court does have the ability to regulate evidentiary matters, such as dispensing with notarization for the in-presence notarization for the purpose of taking and giving oaths, and there may be some sort of procedural rules that the court could change, I don't believe that they can dispense with the witnessing requirements just through sort of judicial decree or order at this point. And let me explain a little bit why I've come to that conclusion for those of you who sort of want to research it on your own or disagree with me and talk me out of it. So there's basically two doctrines that we've been bouncing around as options to dispense or loosen the witnessing requirements, if we even thought that was a good idea. And many people who practice in this area don't think it would be a good idea. But even if we could, the two doctrines that I want to talk about are the harmless error test and the substantial compliance test. And thank you to Professor Lee Ford-Tritt at the University of Florida for helping me work through these issues, because although I teach wills and trusts at FSU, I adjunct, and he is so much better at this stuff and has so much deeper knowledge than I do. So the harmless error doctrine is actually a judicial dispensing power that the legislature can grant to the judiciary in order to let non-compliance with the statutes fly. And what we mean by that is this dispensing power, harmless error, is a statutory provision that you insert within the statute of wills or the probate code for your state that allows the court to forgive sins in the execution or non-compliance with the statute of wills. That doctrine oftentimes comes with some evidentiary requirements. You have to have the trier of fact, conduct an evidentiary hearing, conclude typically with clear and convincing evidence that although the strict statutory requirements have not been complied with, the errors were harmless. And once the court has that evidentiary foundation and makes those findings of fact, then the court can sort of forgive the sin of non-compliance. The problem with that provision right now is that Florida has never put in their statute of wills a harmless error dispensing power. The judiciary simply doesn't have that discretion to dispense with the statutory requirements right now. And whether we could even get the legislature to insert something like that is sort of irrelevant right now because the legislature isn't in session right now. But even if they came back on a special session, and even if we could get on the agenda for such special session, as if they don't have more important things to do right now, the question is whether they would. And many practitioners would not support that type of dispensing power, at least unless it was severely limited to situations like this, like times of emergency. But even if the legislature would do it, lots of questions about whether it could be inserted retroactively to apply to the execution of wills that are happening right now, whether it was limited to just errors that occurred right now, whether it would even apply to something that was not truly an error, but almost an intentional dereliction or an intentional non-compliance. I don't have two witnesses, so I'm just going to sign it anyway. That's not necessarily an error. That's intentional and knowing. Lots of questions about if the legislature could do this, what it would look like. But certainly, if the legislature was inclined to do that, the reptile section would be willing to, help lead that discussion. But right now, there's no dispensing power within our statute of wills that would forgive that type of execution sin. So it's sort of all speculatory at this point as to whether that might solve the situation in retrospect. The other thing that we've sort of talked about is the substantial compliance test. And what substantial compliance, unlike harmless error, which is a statutory or legislatively inserted dispensing power given to the judiciary, substantial compliance is an equitable principle. And for those of us who practice in trusts and estates, we know that courts generally have equitable powers to make things right, to make things fair. And so substantial compliance is actually a power of the judiciary to dispense with the formalities of will execution when and if the court finds that substantial compliance with the statute has occurred. Again, in those circuits that have used, or those jurisdictions that have used substantial compliance, there's an evidentiary foundation required. There's typically a finding of fact that there was clear and convincing evidence of substantial compliance, things like that. But even in jurisdictions where substantial compliance it has been used, the problem here in Florida is that we've got, while we do have equitable powers and the courts are not necessarily shy about using those equitable powers, they have been in the past pretty shy about using, any equitable powers to forgive irregularities or non-compliance with the statute of wills. There's ample examples of execution errors. Husband signs the wife's documents and vice versa, or witness signs or testator signs in the presence of two witnesses, but the two witnesses don't actually sign. They were there, but they didn't lay pen to paper. Other situations where you've got only one witness instead of two. There's no fraud involved. There's no reason to believe that is not the testator's testamentary plan. There's just not strict compliance with the execution requirements, and therefore the court declines to admit the will to probate. There is a fair amount of judicial loosening of strict requirements related to wills and trust. We now have reformation of wills, which we didn't have before. We have seen the loosening of parole evidence rules for will construction proceedings, lots of things like that make us think that the court would try to do equity in these situations. But right now, it's hard to tell anybody that with respect to a failure to comply with the strict execution requirements, that the court would use its equitable powers to find substantial compliance is enough. So, I recognize that out of necessity, we may see some wills that are not properly executed, and the court may perhaps use their equitable powers or something like substantial compliance to move away from the strict construction requirements that they typically have. But that would be a changing of precedent, a loosening of sort of the requirements, and so I wouldn't encourage anyone to rely on that at this point. And so to the extent that something like that has occurred out of necessity, you definitely want to at least ratify those documents when and if you can at some future date. So to sort of conclude, I don't know what options are out there right now to eliminate the witnessing requirements with any reliability that these wills could be or would be probated in the future. We continue to keep an eye on this, and if you've got ideas, feel free to circulate them around and let me know. But that's my 2 cents right now. It's not the opinion of the reptile section. Certainly don't rely on it. Do your own research. But I've taken a fairly deep dive into this stuff with the help of a lot of colleagues and others in the section, and that's just sort of my 2 cents right now. So I hope this has been helpful to you. The section is going to try to keep pushing out information that we think is going to be helpful in short order, probably in podcast or short text, short article form, so that you can digest it as quickly as possible. I hope that this has been helpful. Thanks. Stay safe.